Hey everyone, and welcome back to the Deep Dive. Today we're going to be tackling insolvency resolution in India, but with a bit of a twist. We're going to be looking at the potential of using mediation.
Exact.
And to guide us through all this, we've got a fantastic report fresh off the press from January 2024, the Expert Committee report on using mediation under the Insolvency and Bankruptcy Code 2016. It comes straight from the Insolvency and Bankruptcy Board of India, the IBBI for those in the know, and they've really gone all out, gathering research, consulting stakeholders, and even taking a peek at how other countries are using mediation successfully.
It's a global view.
It is. And you know what else is really interesting?
What's that?
India just got itself a brand new Mediation Act. And globally, mediation has even helped resolve some massive insolvency cases, like Lehman Brothers.
Oh, wow.
So the big question is, what does all this mean for resolving insolvency disputes in India?
Well, it all starts with India's Insolvency and Bankruptcy Code. You know, the IBC. The whole idea was to create a system that could revive companies that are struggling and make sure that creditors get the best possible outcome. And you know what? It's actually working. Through the IBC, creditors have recovered a significant amount of money, over Rs 3.16 lakh crores to be exact.
Wow, that's incredible. It sounds like the IBC is making a real difference.
It is, and there's even more. Before cases even reach the National Company Law Tribunal, the NCLT, a whopping Rs 9.33 lakh crores of debt has been settled. Just by having the IBC in place, people are encouraged to resolve their insolvency issues proactively.
That's amazing. It's almost like it's created a whole new culture around resolving insolvency in India.
Yeah, exactly.
But I'm guessing it's not all smooth sailing. I mean, there must be some challenges, right?
Oh, absolutely. One of the biggest ones is delays. More than two-thirds of corporate insolvency resolution processes, CIRPs, are taking longer than the IBC's timeframe. On average, resolution takes 653 days, and liquidation takes 472.
Oh, wow. I can only imagine how frustrating that must be, especially when you consider that for anyone going through insolvency, time really is money. Those delays must feel like an eternity. So is that where mediation comes in?
It could. It offers a much more collaborative way to resolve these disputes. It brings everyone together with a neutral third party, a mediator, to guide them towards a solution they can all agree on.
So instead of battling it out in court, it's more like having a structured conversation, aimed at finding some common ground.
Exactly.
So what are the advantages of that approach?
Well, for starters, it's much faster and cheaper than going through litigation. Think less time in court and lower legal fees.
That's gotta be a relief, especially when you're already dealing with a stressful financial situation. It's like taking a shortcut through a legal maze.
Exactly. And there's more. Mediation gives you the flexibility to come up with creative solutions, the kind of solutions a court might not even consider. It's about tailoring the outcome to fit everyone's specific needs.
So it's not just about winning or losing, it's about finding a solution that actually benefits everyone.
Precisely. And because it's more cooperative, mediation can even help preserve those valuable business relationships. Plus, it's all confidential. Sensitive financial details stay private.
So it sounds like mediation could really change the game for people going through insolvency. But what about India's new Mediation Act? How does that fit in with all of this?
Well, that's where things get interesting. While the Mediation Act aims to promote mediation across the board, it actually excludes the IBC.
Oh, really?
Yeah.
That seems counterintuitive.
It might seem that way.
Right.
But the expert committee actually recommends creating a separate framework specifically for insolvency mediation within the IBC itself.
Oh, I see. They're acknowledging that mediation has potential, but they're saying it needs to be tailored to the unique challenges of insolvency cases.
Yeah.
So it's not a one-size-fits-all approach. It's more like a custom-fit solution. That makes sense. So if we're going to build this specialized framework, what are the key ingredients? What makes for successful insolvency mediation?
Well, the committee highlights a few critical factors. First off, participation needs to be voluntary. You can't force people into mediation.
Right. It has to be their choice.
Exactly. They need to feel like they have control over the process.
Makes sense.
And then you need to be really clear about what you're trying to achieve. What types of disputes are suitable for mediation? At what stage in the insolvency process should it happen? You need to define all of that up front.
So no ambiguity, just a clear roadmap for everyone to follow.
Right. And then, this is crucial, you need specialized mediators. We're not talking about just any mediator here. You need people with deep expertise in insolvency law and how it works in practice.
So they need that double-edged sort of knowledge, both the legal complexities and the practical realities of insolvency.
Exactly. And you need the right infrastructure, too. The report specifically calls for a dedicated insolvency mediation cell, a physical space with all the resources needed to administer the process smoothly, attached to the NCLT.
Dedicated resources, dedicated space. It sounds like a well-oiled machine.
That's the goal. And finally, to make sure those mediated agreements have real weight, they need to be legally binding. This ensures compliance and prevents those frustrating delays from creeping back in.
So everyone knows what's expected of them, and there are consequences for not following through.
Yeah.
This is all sounding really promising. But let's get specific. What kind of disputes do they actually see mediation helping with? And at what point in the insolvency process would this happen?
Well, the committee actually gets into the nitty-gritty, identifying specific disputes and stages where mediation could really shine. A prime example is the pre-insolvency commencement stage.
So before things even reach the NCLT.
Exactly. They see this being particularly beneficial for operational creditor-initiated CRPs, especially when there's only one operational creditor involved. The idea is to resolve those disputes early on, before they escalate into a full-blown insolvency case.
It's like nipping it in the bud.
Exactly.
Prevention is better than cure.
Right. And here's something interesting. The data shows that a high percentage of these operational creditor-initiated cases are already being settled before they reach the NCLT. So there's clearly a willingness to find solutions early on.
So mediation could provide that structured way to make those early resolutions happen.
Exactly.
That's fascinating. What about other stages in the process?
During the claims collation stage, mediation could be incredibly helpful. This is where things can get a bit messy. You have disputes over how much each creditor is owed, how they're classified, and what happens when claims are rejected.
I see. So mediation could streamline that whole process, saving everyone time and potentially avoiding even more litigation down the line.
Exactly.
And what about once a resolution plan is in place?
Well, even then, mediation can come in handy to address any disputes that arise during the execution phase.
So it's about making sure that resolution plan stays on track. Yes.
And doesn't get derailed by unexpected disagreements.
Exactly.
Wow, they've really thought this through, identifying all these different stages where mediation could play a role.
They have.
But now we need to think about the practicalities. Will this actually be accessible for everyone?
That's a great point.
And will it actually work in practice?
Absolutely.
Because let's face it, cost can be a major barrier, especially when you're already struggling financially.
Right. Well, the committee has actually proposed a system where the parties share the mediation costs equally, but they've also built in some flexibility, allowing parties to agree on a different split if that works better for them.
So shared responsibility with some room for customization.
Exactly.
But what about finding the right mediator? We've talked about the need for specialized expertise. Will there be enough qualified people available?
Well, the report addresses that too. They propose specific criteria for mediators, including retired judges, senior advocates, insolvency professionals, people with the experience and knowledge we've been discussing.
So a pool of seasoned experts.
But what about those who are newer to the field?
Well, that's where it gets really interesting. They actually suggest creating an additional pool of mediators, which would include legal practitioners with at least 10 years of experience in insolvency disputes, seasoned commercial dispute mediators, and even technical experts with a decade or more under their belts.
Oh, wow. So it's a two-tiered system.
Yes.
Ensuring both deep expertise and fresh perspectives.
Exactly.
But even with the right people in place, you need the right infrastructure, that dedicated space to make it all work.
Right, and the report really emphasizes that. They highlight the importance of a dedicated insolvency mediation cell, a physical space with the staff and resources to support not only traditional mediation, but also e-mediation.
Wow, so a modern, well-equipped space that embraces technology to make the process as smooth as possible.
Exactly.
It sounds like they've really tried to anticipate those potential challenges
They have.
and come up with solutions.
That's right.
They haven't just focused on the what of mediation, but also the how. Recognizing that those practical considerations are going to be crucial for making this framework a success.
Absolutely.
This has been incredibly insightful. We've covered a lot of ground in this first part of our deep dive into mediation and insolvency, from the challenges facing the current system to the potential solutions that mediation offers. But there's so much more to explore when we come back. We'll delve deeper into those key factors for successful mediation and look at some fascinating real-world case studies that really illustrate its power. So stay tuned. Welcome back to our deep dive into insolvency resolution and this exciting world of mediation.
It is exciting.
It is. Before the break, we were getting into the nitty-gritty of what makes for successful mediation, especially as it applies to insolvency here in India, looking at the expert committee report, talking about infrastructure and specialized mediators, and making sure those agreements actually have some teeth. But, I think it's worth taking a step back for a second and asking, why should all this even matter to someone who's right in the thick of things, dealing with insolvency?
Yeah.
What's the takeaway for them?
That's a really great question. And it gets to the heart of why this report is so important. The potential benefits of getting this right, of creating a successful insolvency mediation framework, are massive.
So paint us a picture. What does success actually look like?
Well, imagine a world where these disputes are resolved quickly, cost-effectively, and without all the animosity. That's the promise of mediation.
So less time wasted in court, fewer legal fees eating into those already stretched resources, and maybe even a chance to save some of those business relationships.
Exactly.
Sounds like a win-win.
It really does. And remember those core goals of the IBC.
Reviving those struggling businesses
Yes,
and
sure.
making sure creditors get the best possible outcome.
Exactly. Mediation helps us achieve all of that, but in a way that's more efficient, less adversarial.
So we're not just tweaking the system a little, we're talking about a completely new culture around resolving insolvency.
Yeah, I think that's a great way to put it.
But big changes like this, they often come with some questions,
Of course.
concerns, maybe even a little skepticism. Will it actually work in the real world, or is this just a good idea on paper?
Right. Well, I think the best way to address those concerns is to look at what's already happening, to look at real-world examples, case studies, both here in India and internationally. They really show us the power of mediation in these insolvency situations.
Love a good case study. They always help bring things to life.
Me too. So remember we were talking about those operational creditor-initiated CRPs?
I do.
Well, there's this really interesting case, Intech Capital Limited versus Jagtar Singh & Sons Hydraulic Private Limited, where the parties actually did try to settle through mediation. But things didn't quite go according to plan.
Oh, what happened?
Well, they reached an agreement. And they even got the NCLT to approve withdrawing the CIRP application. But then, the corporate debtor, the company facing insolvency, they failed to uphold their end of the bargain.
Oh, no. So all that effort, and they end up back where they started.
Pretty much. The financial creditor had to go back to the NCLT, and the CIRP was reinstated. So this case really highlights how important it is for those mediated agreements to be legally binding.
So everyone knows what's expected.
Exactly.
And there are consequences for not holding up your end of the deal.
Right.
It's a tough lesson, but a valuable one for sure. So we've seen how things can go wrong, but can mediation really handle those big, complex insolvency cases?
That's a great question. And that's where those international examples come in. Remember that Lehman Brothers case we talked about?
The biggest bankruptcy filing in U.S. history.
That's the one. Over 6,000 counterparties in their derivatives division alone, claims totaling billions upon billions of dollars.
It's hard to even wrap your head around numbers that big, so how do they even start untangling that mess?
Well, mediation played a key role. The court actually ordered mandatory mediation to try and resolve those incredibly complex derivative contract disputes. It worked. By 2016, over 100 mediations had brought in over $300 million for the Lehman Brothers estate.
That's amazing. It really shows you the power of mediation to find solutions where traditional litigation might just gotten completely bogged down.
Absolutely. And it highlights that flexibility we talked about.
Right.
How mediation allows for more creative solutions.
Right.
Solutions that a court might never consider.
Right.
That was essential in the Lehman Brothers case.
Because they were dealing with such unique financial instruments.
Exactly. Mediation gave them the space to figure out how to maximize value for the creditors in a situation that had never really happened before.
It's almost like mediation allows you to navigate those uncharted waters.
That's a great way to put it.
To find solutions when there's no clear roadmap.
Yes.
And that's where those specialized mediators really come in.
They do.
With their expertise and their ability to think outside the box.
Absolutely.
We've talked a lot about the legal and financial aspects of insolvency, but what about the human side of things? Insolvency can be incredibly stressful, emotionally charged, and often quite contentious.
Right.
Can mediation really help navigate those choppy waters?
That's a great question. It touches on something really fundamental about mediation. It's not just about the money. It's about communication, understanding where everyone's coming from, and finding that common ground.
So remembering that behind all the legal stuff and the financial figures, there are real people with real problems
Exactly.
and real emotion.
And that's where those skilled mediators really make a difference. They're not just legal experts. They're facilitators, helping people communicate more effectively, manage those emotions, and find solutions that address both the practical and the human side of things.
It's about seeing the bigger picture
Yes,
and finding solutions that actually work for everyone involved.
exactly.
It's almost like conflict resolution therapy for the business world.
I like that.
But it's also about recognizing that insolvency doesn't have to be a zero-sum game
Right.
where there are clear winners and losers.
It doesn't.
It's about finding those win-win solutions where everyone can feel like they achieved something positive.
Even in the midst of a challenging situation.
Exactly.
And that's why this report is so exciting. It's not just about a new legal framework. It's about a more collaborative and humane approach to resolving these disputes.
It's about changing the way we think about insolvency.
It is.
This has been really insightful. We've explored so much in this second part of our deep dive, but there are still some questions to answer. When we come back for part 3, we'll address those head on. Can mediation really become the go-to solution for insolvency disputes here in India? What are the potential hurdles we might encounter along the way? Stick with us. We'll be right back.
And we're back for the final part of our deep dive into mediation in insolvency.
This final frontier.
It is. So far, we've seen how India's new Mediation Act, while not directly applying to the IBC, has really sparked this movement towards creating a specialized framework for resolving these insolvency disputes amicably.
Yeah, it's a big shift.
It is. And we've delved into those real-world examples, the successes, the cautionary tale.
You're good in the back. Exactly, to really highlight the power and sometimes those complexities of using mediation. But as we wrap up our deep dive, I want to look ahead. What does the future hold for mediation in insolvency in India?
Well, I think we're at a really exciting point. We're potentially on the cusp of a major shift in how we approach insolvency resolution.
It feels like it.
Yeah. This expert committee report, it's not just some theoretical document.
Oh,
It's a call to action. It lays out a blueprint for creating a system that's more efficient, more collaborative, and ultimately more effective.
So it's not just about adding mediation as another option. It's about rethinking the entire system.
Exactly.
But big changes like this, they don't always come easy. What are some of the biggest challenges you see?
Well, I think one of the biggest ones is going to be changing mindsets. Traditionally, insolvency has been very adversarial. It's all about litigation, which often leads to these really long, drawn-out legal battles, draining resources, creating more tension.
Yeah, it can get pretty messy.
It can. So shifting to a more collaborative, mediation-centric approach, it requires a real shift in thinking.
So moving away from that I win, you lose mentality
Exactly.
and embracing a more we're all in this together kind of approach where
Right.
everyone can potentially come out ahead.
Yeah, and realizing that collaboration can actually lead to more sustainable outcomes.
Outcomes that benefit everyone involved.
Exactly.
But how do we get there? How do we convince people that mediation isn't just some soft option, but a really powerful tool?
Well, I think awareness is key. The more people understand about mediation, its benefits, how it actually works, the more likely they are to embrace it.
Makes sense.
So education and outreach are going to be crucial.
So things like workshops, seminars,
Look like.
maybe even incorporating mediation training into professional development programs.
Exactly.
For lawyers, judges, insolvency professionals.
Right.
So spreading the word,
Yeah.
showcasing those success stories,
Yes.
and making sure people understand that mediation isn't something to be afraid of. It's a practical and effective way to resolve these complex disputes.
Absolutely.
But it's not just about changing the minds of those directly involved in these cases, is it?
No, it's not.
The system itself needs to be set up to support this new approach.
You're right. We need that infrastructure in place. Those specialized mediators,
Right.
training programs, and dedicated spaces to facilitate those mediation sessions.
And we can't forget about technology. Mediation could be a game changer, especially in a country as vast as India, allowing people to participate remotely.
Absolutely. Embracing technology is going to be essential.
And what about the legal framework? I mean, the report is great, but how do those recommendations actually translate into concrete laws and regulations?
Yeah, that's going to be critical.
To make sure mediation has the support it needs.
Right. We need clarity around how it's going to work. Clear guidelines for everything from mediator qualifications to the enforceability of those agreements.
It's a big task,
It is.
but it's essential.
Absolutely.
And what about funding?
Right. Well, that's another key piece of the puzzle.
Creating this infrastructure, training mediators, promoting awareness.
It all costs money.
It does.
And it's going to require investment from the government, regulatory bodies, even private sector stakeholders.
It's about recognizing that this isn't just an expense. It's
Right.
an investment that will ultimately benefit everyone.
Exactly.
But even if we overcome all those hurdles, there's still that big question. Will it actually work? Can mediation really become the go-to solution for resolving insolvency disputes in India?
What? Only time will tell. But here's what makes me optimistic. There's this growing recognition, both here in India and globally, that the old way of doing things, that adversarial approach to insolvency, it doesn't always work.
It's not the best solution.
It's not.
People are starting to realize that there's a better way,
I think so.
a more collaborative way
Yeah.
that's focused on finding solutions that work for everyone.
Exactly.
Not just about winning or losing.
Right.
And that's where mediation really shines.
It does.
It offers a real alternative,
A path towards resolving these disputes in a less destructive way.
a more sustainable way.
Exactly.
That's aligned with the spirit of the IBC, which at its core is about reviving businesses and maximizing value for creditors.
Absolutely.
So while there are no guarantees, there's definitely reason for hope.
There is.
The potential is there. The will is there.
We have a blueprint.
We do. Now it's up to all of us to make it happen.
I agree.
Well, we've reached the end of our deep dive, but we want to leave you with one final thought. If mediation does become the norm for resolving insolvency disputes in India, what kind of impact could that have on the economy as a whole? Could it lead to a more robust and resilient business environment? Could it foster greater trust between debtors and creditors? Could it even pave the way for a more collaborative business culture overall? These are some big questions, and we'd love to hear your thoughts. Connect with us on social media, share your insights. Until next time, keep diving deep and keep exploring the world with curiosity and an open mind.